Yes, hello everyone. Welcome. It is a great pleasure today to introduce Professor Mark Suchman, who is a distinguished scholar in the fields of sociology, law, and organization theory. Professor Suchman is currently professor of sociology at Purdue University and a research professor at the American Bar Foundation, where he previously served as executive director. His research focuses on the impact of the legal institution on the organization and economic life, particularly how legal environments shape opportunities for innovation, entrepreneurship, and technological change. He is widely known for his theoretical work on organizational legitimacy, as well as the role of the law firms, the governance challenges of the new information technologies, and the dynamic of entrepreneurial startups. So Professor Suchman has published extensively in leading scholarly journals, including Academy of Management Review. So we are delighted to have you, Professor, here. So stage is yours. Thank you.
Thank you very much, Leyla. Thank you for the introduction. Thank you also to the Turkish Academy of Management for hosting the session, and for all of you for being here. It's both my pleasure and my honor to talk with you today. So my topic for today, and I think there's a paper that's available to you if you would like, is the legal environment for innovation and entrepreneurship. So before I jump into the substance of my paper, let me give you just a bit of the backstory behind the paper. So the paper that I shared is an invited chapter for the recent Handbook of Innovation and Entrepreneurship, edited by Olaf Sorensen and Pat Thornton, two grad school contemporaries of mine, actually. It's also, in some ways, a distillation of ideas from a seminar on law, innovation, and entrepreneurship that I've taught intermittently over the years at both the undergraduate level and the graduate level to a mix of students with interests in business, in law, and actually some in engineering as well. So, to put you in kind of the right frame of mind, this isn't a paper about any single body of law. It's not a paper about any particular approach to new firm governance. Rather, it's basically a sales pitch. It's a sales pitch for why and how organizational researchers should think and care about law. And as you'll see, it's also a sales pitch for why and how socio-legal researchers should think and care about entrepreneurship and innovation. So the basic pitch here is that the legal environment shapes the opportunities and the challenges that innovators and entrepreneurs encounter. And at the same time, innovation and entrepreneurship shape both subject matter that law addresses and the governance techniques that legal actors deploy. So in particular, I'd like to suggest that although individual ventures may experience the legal environment as a kind of a fixed constraint, at a more macroscopic level, more macroscopic long-term perspective might suggest that law, innovation, and entrepreneurship really represent interlinked technology cycles, you might say, playing out in distinct but overlapping organizational fields. So my argument basically has three parts. First, I'll start with a brief overview of some of the key laws and legal institutions that constitute the legal environment for innovation and entrepreneurship. I apologize for the fact that this is going to be a little bit United States centric, mostly just because I know more about United States law than I do about law elsewhere in the world. But I think much of this translates fairly well. Second, I'll discuss two helpful theoretical models for thinking about law and entrepreneurship coming from research at the intersection of the sociology of law and the sociology of organizations, which is really where much of my work has been. And not everything I'll talk about is my own, but work that I've done with colleagues and work that my colleagues have done is all kind of relevant to that intersection. And then third, I'll offer some thoughts on how those models could be deepened and linked more explicitly to the study of innovation and entrepreneurship by incorporating lessons from research on technology use and on technological change. So, to start, let me just say a few words about the key laws and legal institutions that constitute the legal environment for innovation and entrepreneurship. And for the sake of time, this is just a very quick, 20,000-foot high rundown, mostly to highlight what a broad legal terrain this really is. And I'm going to divide things somewhat arbitrarily into three broad domains. So the legal environment for innovation, the legal environment for entrepreneurship, and what I'm going to call modes of legal impact. So specifically, starting with the legal environment for innovation. Innovation, as I'll use the term here, refers to the creation, the implementation, and the diffusion of new ideas and new practices. Obviously, intellectual property rights are the canonical law of innovation, both because they shape the incentives for research and because they shape and they often constrain the pool of ideas available for future innovators. As is the case with many laws, although we think of intellectual property as being a legal body designed to promote or encourage innovation, the truth of the matter is that intellectual property is a hotly contested body of law, and that intellectual property rights that are too protective of current innovators actually restrict the availability of ideas for future innovators. And so there is some kind of balance, or at least there's a trade-off to that body of law. It's also, though, one doesn't want to get too hung up on intellectual property law as the only law affecting innovation, because it isn't, right? In addition to intellectual property law, there are other bodies of law, some of which facilitate, or at least arguably facilitate, innovation. Things like public funding for research, government procurement programs, infrastructure construction, including scientific infrastructure, labs, lab facilities, the internet, and so on, right? There are also bodies of law that, at least in general, would be seen as impediments to innovation. So things like secrecy clearances, testing and approval processes, regulatory compliance requirements, and of course, product liability lawsuits as well. And I will just, a nod to relatively recent events. Notice that I mentioned as a facilitator government procurement programs, and as an impediment secrecy clearances. This is exactly what has got the AI company Anthropic into a battle with the U.S. Department of Defense over whether they can use Anthropic. Whether at this point, I believe the Trump administration is saying, as a matter of security clearances, nobody who does business with the federal government can use any Anthropic product. But of course, up until now, they have been using Anthropic products, and the government procurement process, until it turned hostile, has actually been an important source of financial support for that technology. So you can see the playoff, the trade-offs between these various bodies of law. But they are all important. I should also add, before I move on, that somewhere between facilitating and impeding innovation, government standard setting projects kind of both constrain innovation by locking in a dominant set of design premises as a standard, and also support innovation by facilitating interoperability, expanding markets, and so on. So standards can get locked in, and the standardized technology may at least temporarily be frozen. But one of the reasons you do that is so that other people can then reliably interact with it, create new technologies, new innovations around it. And one noteworthy feature of many of these laws, including standards, is that by limiting the range of allowable new products, by making them safer, making them more predictable, and more interoperable, they actually facilitate the adoption of new products by end users. So in some sense, the legal inclinations of inventors and marketers aren't necessarily identical. That is, inventors might like to be as unconstrained as possible to design and to test and to deploy any idea or any technology that they come up with. But companies that would actually like to build a market that they could enter where people would buy their products, trust their products, use their products, and so on, may actually welcome at least some of these limitations as a way to in a sense tame or domesticate the innovation so that it becomes palatable for for the larger economy. And that kind of brings us to the next topic, which is the legal environment for entrepreneurship. So, turning to the legal environment for entrepreneurship, as I'll use the term here, centers on the formation and promotion of new ventures, and particularly on the founding of new organizational startups. Unlike innovation, there isn't really a canonical law of entrepreneurship, but perhaps the strongest contender would be the collection of rules governing the formation of new business entities. So sometimes this is referred to as entity formation law. So, how do you set up a sole proprietorship? How do you set up a partnership? How do you set up a corporation? How do you set up a nonprofit? And so on. And it's perhaps worth noting that beyond imparting particular powers and duties to a new organization, the choice of legal form, of entity form, is also a symbolic resource for narrating the startup's fundamental nature and purpose. So, a lot of interesting work on storytelling, on narration that entrepreneurs do in the process of setting up and legitimating a venture. And one of the ways to signal and one might say to make a reliable commitment about what your organization is going to be is by choosing a particular legal structure for it. So if you think about a corporation versus a partnership versus a nonprofit, they're buried in there a lot of assumptions about how hierarchical is this new venture going to be? How distinct is it going to be from the persona of the founder? How open is it going to be to the environment? How long-lasting do you anticipate that it'll be? How growth-oriented is it going to be? How socially responsible, and so on. Some forms are less well-suited for growth. Some forms have a closer relationship to the founder. Some forms, at least in certain legal systems, need to be dissolved at specific points in time, while others are seen as having indefinite lifespans, and so on. So entity formation law provides a kind of vocabulary for establishing the new venture's moral and cognitive legitimacy. But as with innovation, plenty of other laws beyond these, this usual suspect matter as well. So, in addition to entity formation, startups need to access financial and human resources. So, for example, financial regulations and tax policies matter. Labor, employment, immigration law matters as well. Startups also need to access product markets. So, licensure laws, antitrust laws, government procurement rules again, advertising regulations, and so on can all be crucial to how quickly a startup can move to market and what kinds of markets it can access, what kinds of personnel it would need in order to access those markets, and so on. And finally, a bit sort of further below the radar, the legal environment for entrepreneurship also includes things like securities laws and bankruptcy laws that affect when and how the entrepreneurship process ends. So the beginning of the startup process is very much affected by how people see it ending. Does it end in an initial public offering, which would be governed by securities laws? Does it end in some sort of liquidation and sale? Which might be governed by bankruptcy laws or might be governed by corporate takeover laws, and so on, right? So, there are some things that may be uppermost on an entrepreneur's mind at the beginning, like hiring employees and so on, all of which is governed by law. But if you take the perspective of an investor or even a relatively foresightful entrepreneur, thinking about what's going to happen, how are you going to become either a going entity, or if things go badly, how are you going to untangle all of this, is another set of laws that also are implicated in the process. So finally, the last body of law, and I kind of make air quotes around body of law here, that I want to highlight is composed of the procedures and institutions that shape what I'm calling modes of legal impact. That is, how statutes, regulations, doctrines become palpable in day-to-day organizational life, right? Law isn't self-effectuating, and so you need to think about, what is it that actually makes law present, makes people pay attention to it, makes law matter in their business decision making, in their daily lives. And now, in the interest of time, I don't want to belabor this, but there are at least four main modes of legal impact. And so the first, organizational researchers often adopt a pretty narrow, almost stereotypical image of legal impact that begins and ends with what could be called public monitoring and enforcement. So, regulatory agencies may have inspectors, people may require you to submit licenses, what have you. That image of the law may be sufficient to understand legal impact in some highly regulated domains, although, frankly, I can't think of many that begin and end with public monitoring enforcement. But in any case, in most of the economy, if you look more broadly than a few very highly regulated domains, no serious socio-legal analysis would stop with public monitoring enforcement. So, obviously, especially in the United States context, you never want to lose sight of private liability and litigation, right? So people can sue on their own behalf, and often sue on their own behalf around principles like fraud or like environmental harms or what have you, that are very similar to what in other countries might be done through public monitoring and enforcement. So bearing in mind that there is a private litigation route for sanctioning activity that is socially undesirable. One step further removed from the formal legal system, there's also an entire complex of private industry self-regulation, right? And there's a large body of work on not just setting standards for technical interoperability, but setting standards for quality, setting standards for environmental protection, and so on. Private certification organizations, ISO is sort of quasi-governmental, but other organizations like Fair Trade and so on that are engaged in an activity where the primary sanction is that you might be decertified, not be able to use their trademarks being intellectual property, of course. But if for a firm that is in an industry that has these kind of private self-regulatory bodies, their take on what you should and shouldn't do is often as prevalent as important, as visible as the formal legal systems take. And then finally, lastly, ultimately, all of these systems of formally institutionalized impact depend heavily on the informal, diffuse mechanisms of legal consciousness. And that is, how do people think about the law? What do people assume the law does? When is the law salient to them or not? And in what ways? Internalization, so where people take values or principles or categories or what have you embodied in the law and take them into their own moral and cognitive apparatus and simply take them for granted, assuming perhaps that they are also legally relevant. But I know most of us would not commit murder, would not commit fraud, would feel that was wrong. And we would hope that the law would align with it. But if the law ever said, "Oh no, it's okay to commit these kinds of murders," we might at least hope that we wouldn't go ahead and do it just because the legal sanction was absent. So there's a lot of voluntary compliance that goes on around a lot of laws. And of course, work on organizational culture suggests that we shouldn't assume that just because organizations are profit-oriented, that no other sets of motivations, no moral commitments or normative commitments come into play. And so organizations, like individuals, can internalize various aspects of legal structure and sort of legal reasoning into how they themselves interact with their environments. And so, while public monitoring and enforcement, litigation, industry self-regulation are all formalized, and you can go and read those rules, we wouldn't want to assume that that's the only way that the law affects organizational behavior, affects startup behavior. Right. So, in any case, clearly there's plenty of legal environment for innovation and entrepreneurship that we could study. But as a sociologist, I think it's important to have a theoretical framework to keep this from just becoming a grab bag of disconnected bodies of legal doctrine. We don't actually want to have to become legal scholars to understand all of this. And understanding how it works as an organizational process, as an organizational dynamic, is at least as important as understanding the specific terms of any given law. And so, this paper draws on two models from the law and organizations literature in sociology. And the first of these is what could be called the multifaceted legal environment model. It's a model that Laurie Edelman and I wrote about in the late 1990s. In the interest of time, I'm not going to dwell on the model in detail, but the key point is that the legal environment of organizational activity, and we were writing more broadly than just entrepreneurship, but it's true of entrepreneurship as well, that the legal environment of organizational activity has at least four facets corresponding to four very different mechanisms, very different types of purposes of law. And so briefly, these four are, first of all, what we call the regulative legal environment, which reflects the role of law as a vehicle for societal control over organizational activity. So if you think about, for example, environmental protection law or equal employment law or occupational safety and health law or antitrust law, actually, if you think about certain private bodies of law like tort law, that is law for the intentional or negligent infliction of harms, all of those are serving this kind of regulative purpose where they are trying to keep organizations from doing things that, at least from the point of view of lawmakers, are socially undesirable, socially harmful, and so on. So that is kind of the normative effect of law. What are the things that we consider right or wrong in society that we would like to encourage or discourage? The second facet of the legal environment is what Laurie Edelman and I called the constitutive legal environment, which reflects law's role in providing cognitive schemas, templates, and definitions, and so on, for understanding and reproducing a shared social reality. Right? So here, if you think about incorporation law, right, we have some common sense of what it means to be a partnership versus to be a corporation versus to be a nonprofit. Contract law, we have some sense of what it means to make a binding agreement, and so on. Property law, what ownership means, right? You may have positive or negative feelings toward ownership, or you may have positive or negative feelings toward corporations, but they are socially meaningful categories. And each of those bodies of law has within it quite a bit that isn't really about right and wrong, but rather is simply about what are the objects in our social world, right? It's constituting various recognized features of our social world. And I will say, even laws that on their face look very much like regulative laws. So, for example, a law against pollution, or actually in my own research, I've done some work on patient privacy. And so in the US, we have a patient privacy law, very much looks like a regulative law about what organizations should and shouldn't do. But if you actually read that statute, it begins with several pages of definitions. This is what we will consider protected health information. This is who is a patient. This is who is a caregiver, and so on and so forth, right? And so even within those otherwise regulative statutes, there's this definitional constitutive activity going on, saying, again, who are the relevant players, what are the relevant phenomena, what are the relevant objects in this domain of activity. So alongside regulative and constitutive law, we have two additional bodies of law that are a little farther from the statutory law, a little bit more private, but still quite relevant to organizations. So the third is what we've called the facilitative legal environment, which reflects the role of legal institutions as facilities or as arenas, that is, systems of platforms, personnel, procedures, and so on, that house various types of interorganizational interactions, including most prominently disputing, right? So this is where, if you're thinking about litigation, whatever else it is an ongoing organizational activity that takes resources, that takes attention, that involves winning and losing, that makes or breaks reputations, and so on. And the procedural rules, the rules of civil procedure, the rules of administrative procedure in the United States, and so on, create the forum where these kinds of disputing activities take place. And so, so this is a third aspect. The disputing may be about some constitutive or regulative claim in the law, but disputing itself is an organizational activity, drives attention, distributes resources, and so on. And so the procedural aspects of law may be as important as the substantive aspects in determining how the law affects that process, affects the disputing process, for instance. Finally, the last of the four environments is what I've called the professional legal environment. And basically, the idea here is just to remind ourselves that law is, among other things, an organizational field. That is, there are organizations doing law stuff. There's this matrix of practitioners and organizations that carry out the daily activities of the legal system. And those practitioners and organizations, they are organizations, right? They have the full range of intra and inter-organizational processes, pressures, proclivities. They have their own cultures. They consume they consume resources. They engage in market activities and so on. So if we think about law firms, administrative agencies, standard-setting organizations, and so on, their existence as organizations, they exist because of their role in the legal system. But as organizations, they are also competing with other employers. They are also providing services. In my own work on Silicon Valley, when I looked at Silicon Valley law firms and what they were doing for their clients, one of the most important things they were doing was essentially providing non-legal business consulting. And so in that sense, they are competitors for other firms that might provide provide business consulting for startup companies. They are operating in an organizational environment where they're making networks. They're engaged in organizational learning. They're engaged in the dissemination of models and so on. And so thinking about their characteristics of organizations is also important to understanding how the law might affect a given setting. Right. So the value of this typology is that it provides a framework for thinking about law in ways that resonate a bit less with law school course titles and a bit more with theories of organizational behavior, interorganizational environments, and so on, including, of course, theories of innovation and entrepreneurship. A second useful law and organizations theory for our purposes is Laurie Edelman's legal endogeneity cycle. So basically, and here's a cite. I believe it's the second chapter of the book has a very nice, concise description of this model, though I will run through it briefly today. But basically, this is a dynamic model of how initially ambiguous laws acquire taken for granted meanings, both among legal professionals and in extra-legal organizational life among managers and workers and so on. And so the model has 6 stages or 6 phases, and I'll run through them just so you get a sense of how this cycle works. And so the first stage is ambiguous law. That is, you have a legal discontinuity of some sort. Most obvious would be a new statute, but it could be a new court opinion or a new interpretation or what have you. But you have a legal discontinuity. Essentially, all legal discontinuities are ambiguous. First of all, language is inherently indeterminate. It is impossible, just as a matter of the philosophy of language, to say something that is entirely unambiguous to all listeners in all ways. In addition, legal language is sometimes intentionally ambiguous because, as one of my professors, Jim March, used to say, he had a bunch of great aphorisms, and one of them was, ambiguity preserves consensus. If you want to get people to agree to pass a statute, one of the ways to do that is to make the wording sufficiently ambiguous that everybody essentially makes a bet that down the line, some judge or some enforcer or what have you might interpret that statute their way, right? And so there is a kind of political expedience that drives a certain amount of ambiguity. And then, of course, there's also the ambiguity that simply comes from cognitive unfamiliarity. If people haven't seen a statute before, for a while, at least, it's going to take them time to make sense of what it says, what all its provisions are. A statute can be hundreds of pages long, and it isn't initially always clear how all those pieces fit together, no matter how explicit the lawmaker or the regulator wanted to be. So ambiguous law draws the attention of actors in the legal field. Lawyers, for example, know that they should understand the law, but there are no clear implications to the law yet. And it may not even be on the radar of non-legal organizations. So the next phase is the process of professional framing, which is basically a process of sense making within the legal field. So there are two aspects of this. One of them is simply interpretation. That is, what does the new legal development mean in light of pre-existing doctrines, in light of pre-existing legal logics, and so on? When a new law comes out, lawyers who practice in that body of law, spend a decent amount of time just engaged in sense making about what exactly is this thing, how is it supposed to work, how does it fit together, what arguments could we or could we not make about it, and so on. The second aspect of this professional framing is actually more about marketing. That is, how are we going to convince our clients to care about this new law and, frankly, to pay for legal help in applying this new law, right? And so, some work on how lawyers try to frame new statutes, and there is this interesting sort of risk-reward trade-off where lawyers try to, first of all, frame the new law as having risks, frame perhaps various kinds of responses to the law as having rewards, and frame their own services as being efficacious and crucial to reaping those rewards and avoiding those risks. And so, thinking both about what the law means and also about how are we going to explain this to non-legal actors in a way that's going to make them want our services to address it are two parts of this professional framing of the legal change. The third stage in this process is what Edelman has referred to as the diffusion of symbolic structures, and this involves the formulation and the adoption of various response models, ways of responding to this law, bundles of things you might do, whether it's employment practices or environmental practices, or maybe it's contractual terms you might want to add into a contract or what have you, right? And the reason these are symbolic structures doesn't mean that they have no substantive effect, right? It means that, among other things, these structures, these models, are gestures of attention to the law. Right? They are ways of saying, I'm taking the law into account here. They can, of course, have real substantive effects too. They may have intended substantive effects. They may have unintended substantive effects. But at the very least, they are about communicating an attentiveness to the law and obviously communicating that you aren't intentionally trying to break the law. The fourth stage, importantly, is what's known as what's referred to as managerialization. And this is kind of a second round of sense making. This time, not sense making within the legal field so much as sense making outside the legal field. And so basically, this is about articulating a rationale for compliance within the logic of various extra legal fields. So some of the logics that you often see getting embedded into the interpretation of legal changes, a logic of managerial coordination and control. I'll pause for a second, tell a story from my work on health privacy law. At one point, I was observing some compliance meetings at a large medical center, and they were talking about the risk that patient information might be revealed over the PA system. And one of the hospital administrators there suggested that they say that medical personnel have to clear everything before an announcement is made on the hospital PA system, public address system. And one of the other people around the table brightened up and said, great, that's going to keep the residents and interns from announcing birthdays over the PA system the way they've been doing, right? Obviously, announcing a coworker's birthday has nothing to do with health privacy, but as a manager, you might understand why you don't want to, especially a hospital manager, right? Why you don't want doctors to feel that they just have the privilege to appropriate the PA system for whatever kind of personal information, whatever kind of personal updates and news they want to share. And so managerial coordination and control gets embedded into this process of legal compliance in that case. Obviously, other logics like shareholder value, worker loyalty is often important around equal employment law and so on, saying, well, if you do this, workers will have more corporate spirit. They will be more willing to come to work. They'll be less hostile, what have you. Customer satisfaction often gets embedded into various kinds of health and safety laws and so on. So this process of managerialization does two things. So first, it may dilute the law's purposes. So there's a lot of sense that, for example, affirmative action law in the United States became corporate diversity management, which doesn't have the same social justice implications. Is much more about the business case than about the social justice case. Or environmental laws might be transformed, managerialized from being about preventing pollution to being about making efficient use of resources, or adopting new technologies or what have you to keep you on the technological front, cutting edge, right? So managerialization dilutes some of the purposes, at least of the activists who may have promoted a law, but at the same time, it often broadens the law's reach, because in the United States, for example, certain equal employment laws don't apply to small companies with less than 50 employees. And yet once things like an employee grievance process has come to be seen as being the sign of modern management, crucial for corporate culture, what have you, even smaller companies may adopt that, even though they're not directly subject to legal enforcement. So instead of it broadens it, so some of the internalization mechanism for legal impact comes into play even for companies that are not necessarily subject to public monitoring and enforcement or litigation, right? So the final two stages of this cycle are about stabilizing and institutionalizing these new socially constructed legal meanings. So first, to stabilize and institutionalize them within the extra legal field. That is, organizational actors, managers, and so on, mobilize the new symbolic structures. They make the law real by putting it to use. So they adopt an employee grievance procedure. They buy smokestack scrubbers for their factories, what have you, right? They take this model of compliance or this model of legal attentiveness, and they put it into place as a set of workplace and organizational practices. And they mobilize it as a set of practices in the workplace. And then finally, the last stage is a process that takes place in the legal field where institutional actors, for example, courts, defer to the extra legal field's dominant understandings. That is, courts, for example, take appropriate use of these symbolic structures as evidence of good faith, as evidence of blamelessness. If you have these kind of processes in place, you are doing your best, because when we look across the industry or when somebody gives testimony about what is an industry standard, you are living up to as much as we could hope for, right? So, if you think about anti-discrimination practices in the workplace, the question no longer becomes, is there discrimination in your company or not? Your company's liability depends on whether you put in appropriate kinds of training, appropriate kinds of grievance processes, appropriate kinds of appeals, appropriate kinds of disciplinary practices. And if you as an organization are doing all of those things, even if discrimination is still going on, you as an organization may not be liable for it. I mean, this is essentially the legal system taking these models and saying, we're not managers. We don't know what's feasible, what's good enough. But if all the companies in the industry are doing this, maybe this really is what can be done. This is the most that can be done. And that becomes, in effect, what the law means. Right? I should say, since I've been drawing a lot of examples from EEO law, Edelman's own work focuses on EEO law. But you could actually take this model, you could apply it to intellectual property doctrines, you could apply it to corporate takeover defenses, You can apply it to various aspects of contractual provisions and contractual interpretation and so on. They they work very similarly, and you can sort of play through how this would work. But ambiguous contractual terms, things like poison pill takeover defenses, right, went through this same process of going from being ambiguous, people didn't know how they would work or whether they would work, to people making sense of them and applying them, and ultimately courts, in a sense, validating them. So, here we go. Many of you may have noticed in listening to this, this legal endogeneity model, may have perceived a striking parallel here to what's known as the technology cycle model in the technology management literature. For the rest of you, I'll spell it out just a bit. So in the literature on technology management, there is this widely used concept of a technology cycle. Basically, the technology cycle is a punctuated equilibrium model of technological change within an industry or within an organizational field. And it has 4 phases to it. The first phase, and I realize this is probably tiny type that you can't read, but I will talk through it. The first phase, well, it's a cycle, so a cycle doesn't have a first and last phase. But where we're going to start is with what's known as an era of incremental change, where you have an established technology. The literature also refers to these as a dominant design. And that dominant design may be undergoing various ongoing refinements, but they're relatively minor. They're only marginal improvements. They don't significantly disrupt the industry. They don't disrupt organizational structures. They don't disrupt workplace practices dramatically, and so on. To think about what the legal equivalent would be, this would be a period of settled law, where the law is in place. People basically think they understand what it means. There may be a few lawsuits about, a few idiosyncratic provisions, but basically, everything is recognized and stable in a particular dominant model. The second stage, the punctuation, is what's referred to as a technological discontinuity. It's a radical, potentially industry transforming breakthrough. Terminological note, technological discontinuities can be either competence enhancing or competence destroying. Both types entail order of magnitude changes in the operation of the industry, but competence enhancing discontinuities build on existing knowledge and practices. They reinforce existing patterns of power and authority. They basically make the dominant firms even more dominant, the subordinate firms even more subordinate. And the same thing for groups in the workplace. The dominant groups or dominant professions become even more dominant. Subordinate professions become even more subordinate, and so on. They make the industry more like what it was before. Competence destroying discontinuities, on the other hand, require new skills. They require new routines. They provoke extensive and disruptive restructurings. They often provoke sort of extinction events for certain kinds of organizations, dramatic increases in other kinds of organizations, and so on. They turn the industry on its head in some sense. Either way, discontinuities are more like discoveries than like products, right? They're not yet ready for prime time. The legal equivalent would be an ambiguous legal mandate, right? They are ambiguous technological developments that people still need to make sense of, still need to reduce to practice in some sense. The third phase in this cycle is what's known as an era of ferment. And so this is the period of sense making, right? Firms are experimenting, they're competing, they're collaborating to explore potential designs for putting this breakthrough into use. So this period of ferment is characterized by lots of alternative designs and approaches, lots of uncertainty, lots of indeterminacy about where this is all headed. This is equivalent in the legal cycle, like the period of professional framing, the diffusion of symbolic structures, where people are trying to make sense of what's going on, develop various practices or various products that embody it, and then watching how those do or don't diffuse into practice. the final phase is the dominant design phase, where once a design approach pulls ahead, it eventually, if you think about the literature on path dependence, people begin to jump on board. It eventually gets locked in as the dominant design, as the standard. Sometimes it gets locked in the form of a de jure standard. Other times it gets locked in the form of simply a de facto standard where people are, for various kinds of non-legal reasons, trying to coordinate around this standard. But one way or the other, the industry stabilizes into a new equilibrium. It enters into a new period of incremental change, and that new period of incremental change then lasts until the next technological discontinuity. And so if you think about the legal endogeneity cycle, this is where sort of managerialization, you develop a common model, it gets mobilized, it becomes more and more pervasive, and the legal system defers to it. That's kind of equivalent to the emergence of a dominant design, except it's a dominant legal design instead of a dominant technological design. So, are these legal parallels surprising? Perhaps, but they shouldn't be, right? The professional legal environment, as I commented earlier, is an organizational field. It sells regulatory and constitutive technologies for governance. It sells facilitative technologies for disputing. And so, in some ways, Edelman's legal endogeneity model is essentially the technology cycle of law. That law as a technology is going through a technology cycle, and that's what Edelman's model is picking up and articulating in terms that a socio-legal scholar would recognize, but it is basically a technology cycle going on within the legal field. So this analogy to the organizational studies literature has another important implication as well, which is that the organizational studies literature on entrepreneurship talks not just about when these phase shifts happen, but also about where they happen, where in an organizational field they happen. And can kind of think of two dimensions here. So dimension one is, could be characterized as, broken up stereotypically into designers, producers, and users. So, most creativity comes from, frankly, either designers or users, right? Producers have too many sunk costs. They are busy making widgets on their widget assembly line or what have you, and really don't gain all that much from dramatically creative changes. Yes, incremental changes, maybe a new feature you could, run an advertising campaign around or something, but to actually radically change the technology is, producers don't have so much interest in doing this, but designers, this is how they get promoted, right? This is how they, they get stock options, what have you. Users, this is how they actually get something, that works for them. Their creativity may take the form of hacking an existing technology, jailbreaking a phone or what have you, but it is creativity and deals with, with some of this misfit, this mismatch between design and use. Users tinker to make things meet their needs rather than sticking to the manual, and that is another source of creativity, of innovation. It's actually interesting, in the socio-legal literature, one of the most important or most prevalent distinctions is between law on the books and law in action. And in some sense, that is like the distinction between blueprints and designs and instruction manuals versus how people actually use technologies in practice. And so if you look at, if you or if literature you read is looking at the process, the workplace use of technology, you see a lot of this user creativity, which is very much like technology in action rather than technology on the books. In any case, the second big dimension to think about here, in the entrepreneurship literature in particular, people talk about incumbents versus insurgents. That is, organizational fields are social networks. They have a core, they have a periphery. The core incumbents in an industry, the dominant players, have lots of power, generally at least have lots of power, have lots of resources. They also have a large stake in the existing structure, right? So they tend to favor incremental change or if there's going to be dramatic change, they hope that it's going to be a competence enhancing discontinuity rather than a competence destroying discontinuity. Peripheral insurgents, on the other hand, can see plenty of problems. They can also see how things are done in adjacent fields. And so they may see alternative ways of doing things. And so they have more cognitive breadth as well. But they don't often have the power and the resources to make change happen. And so this is kind of the dominant paradox of social change studies, is that people with the power to change things often have no interest in seeing them change. People who have interest in seeing things change often don't have a lot of power to make that happen. And it turns out the same is actually true in the legal world. So if you look at markers of prestige like law firm size, practice specialties, and so on, the most conservative ones tend to be the most dominant ones. The most kind of disruptive or iconoclastic ones tend to be the more marginal ones. You can also think about sort of a breakdown between regulation and compliance as one kind of legal work, and litigation and activism as another kind of legal work. And regulation and compliance tends to be how the core incumbents in most industries work, right? They have a kind of cozy relationship to the government. They try to get regulatory regime that they can live with. They lobby legislators, they lobby agencies, and so on. And and in that sense are trying to preserve the industry, protect the industry structure, whereas insurgents often are much more likely to be suing or working with various kinds of activist organizations to push for more radical changes. In any case, the final move that the paper makes is to suggest that the legal and the technological domains. Oops, I'm sorry, I should have put this up before, but you can kind of see this breakdown of designers, producers, and users in both incumbent and insurgent positions, right? And so the incumbents are looking for, even the designers and users when they're innovating want things that are competence enhancing, right? The neurosurgeon may be developing a new technique or a new way of applying a tool, but isn't going to want a tool that's going to make the nurses the ones who are doing the procedure. They want to maintain their professional control. And the same sense that a tertiary care university hospital isn't going to want to adopt a technology that's going to empower little regional clinics or something. Whereas the insurgents, the innovators want to promote competence destroying discontinuities. And meanwhile, the producers in both cases either like incremental improvements or they like to reduce things to a dominant design really quickly so that they can get it out on their production line and actually begin mass producing it, right? In any case, the final move that the paper makes is to suggest that the legal and technological domains aren't just analogous, right? So far, mostly I've talked about analogies, but that they're actually interlinked. And that is, the legal endogeneity cycle and the technology cycle jostle one another over time. I don't have enough time to go into this in depth, but just to highlight a few possibilities. So first, and perhaps most obviously, and probably most commonly, a dominant technological design will co-evolve with a dominant legal design. That is, we get a kind of techno-legal governance regime composed of statutes, regulations, precedents, and standards all around how we legally deal with and manage this particular dominant design of a technology, right? So if you think about highway safety law and the automobile, right? The technology and the legal structure are very, very tightly intertwined. And so, the law says you must signal if you're making a right-hand turn, and cars have built-in turn signals that you would use for doing that signaling, and so on, right? And so, once in place, these conglomerations of technology and law tend to develop as a kind of single, technico-legal system, with each component naturalizing and institutionalizing the other. And the greater the integration, the greater the alignment, the more lasting the period of incremental change is likely to be, and the fewer the openings for disruptive innovation and entrepreneurship, right? But integration and alignment are hardly inevitable. the law and technology cycles could diverge. They could diverge in at least three broad ways. So first of all, an incremental change in one domain, either law or technology, could create problems or opportunities that spark a discontinuity in the other, right? So if you think about incremental changes in data ownership law might generate a rash of new e-business models, or from the other direction, incremental changes in search engines might generate a rash of new privacy lawsuits, right? It's not, you don't necessarily have to have a discontinuity in both domains. You might have one of them changing incrementally, but in ways that actually produce dramatic pressures and dramatic discontinuity in the other. Of course, you could also have a discontinuity in one domain that sets off a discontinuity in the second, right? So, deep fake technology could set up, which would be a discontinuity in in video image management, right? Could set off a discontinuity in the law of evidence because suddenly video evidence isn't definitive anymore, right? Or in the recent past, right, the open source general public license, which was a discontinuity in intellectual property law, set off a discontinuity in software production. These more distributed, collaborative software development models, right? Thirdly, a discontinuity in one domain might fail to produce a discontinuity in the other, resulting in this kind of unstable semi-alignment. Where the fields are going along, but the one field doesn't entirely match the premises of the other field. So, as an example, algorithm-driven social media feeds, relatively recent technological discontinuity in social media, so far haven't led to a change in the in the US's Section 230 Internet Liability Shield. The liability shield was very much premised on the idea that all that a web portal was doing was putting up hosting things that individuals had posted. And so, the site shouldn't be liable for the kinds of things that people might put onto it. But if you have an algorithm-driven social media feed, the platform is no longer open to all comers. It is actually prioritizing some things over others, in ways that could be quite socially consequential, and that liability shield doesn't quite make as much sense anymore because it's no longer a content neutral platform. It's actually a platform that is trying to promote various things, whether it's controversial positions or politically palatable positions or what have you, right? So there's a case where the discontinuity hasn't really been fully metabolized in the legal field. The technological discontinuity hasn't been fully metabolized. The legal field hasn't changed yet, right? But it's clearly unstable, and you begin to see, and there's actually right now a lawsuit going on where the parents of a girl who committed suicide as a result of, or at least their claim is as a result of heavy social media use, they are suing, I believe they're suing Meta for having provided that platform and that algorithm, right? Who knows where that'll turn out? Maybe it'll ultimately produce a discontinuity in the legal field as well, a change in that liability shield, but we don't really know that yet. And right now we're in this period of kind of semi-alignment where the law hasn't changed. It's still being applied to the industry, but it maybe doesn't make quite as much sense applied to the industry as it once did. In any case, when legal and technology cycles slip out of alignment, resynchronization can happen through several routes. So when one domain experiences a discontinuity while the other doesn't, the stable domain will often set the terms of debate for the unsettled domain's period of ferment, and arguably at least that favors competence-enhancing contenders because they still have to fit within a pre-existing legal structure that was really built around the previous industry. When both domains are in ferment concurrently, laws and technologies will often coalesce into competing law plus technology platforms, in a sense. Just as we can have a platform of multiple intercompatible technologies, we also can have a larger platform, a technico-legal platform where it's different technologies and different legal understandings together in this period of ferment. And the ferment ends when a winning law/technology platform becomes dominant. So it's a dominant design in both domains, emerges in both domains at once. And maybe that is one of the ways that we get truly competence destroying contenders, is that both the law and the technology have changed into an entirely different way of envisioning the industry and envisioning how it interacts with various internally and with various consumers and government agencies and so on. Oops. So conclusion, the basic point here is that legal fields are organizational fields and law is a technology. So we should understand cycles of ambiguity, sense-making, diffusion, institutionalization in law as being conceptually equivalent to cycles of discontinuity, ferment, standardization, and incrementalism in other technologies. And once we do that, we can begin to examine the legal environment for innovation and entrepreneurship, not as an exogenous force impinging on new businesses, but as a process of coupling and jostling between the cycles of invention, ferment, and routinization in two adjacent, partially overlapping fields. That is the field of law and the field of technology, the field of industry. And this, in turn, might allow us to get a clearer picture not only of innovation and entrepreneurship under the law, but also of innovation and entrepreneurship within the law itself. And so I think that's where I'll stop, but I look forward to hearing your thoughts, questions, comments, reactions. And this particular paper has been published, but there is a more law-focused version of this paper that I'm working on for the annual review of law and social science. And as I said, I teach a seminar around these topics, so I'm always looking for new ideas, or at least looking for people who can highlight to me how things I've said are wrong. So look forward to hearing your thoughts.
Thank you. Thank you very much for your comprehensive presentation. So we can stop recording, I think, right now.